you very much. I'll stop now.
Mr. Hart?
Your Honors, just to pick up where Mr. Barbaro left off,
You're not using his rebuttal time up now, are you?
I think that you don't just ask for a trial as relief. Trial is about something. The complaint states what they're seeking.
I guess the question before us is whether they should even have a chance to prove their assertions.
Whether, if they did, that would be a violation of the New York State Constitution, as it's been interpreted by Berenson and its progeny. And obviously we think not. It is a constitutional challenge because they state that the zoning amendments fail to provide for low-income housing. So that, I think that's the gravamen of their claim, that there's some kind of obligation, whether it's a Mount Laurel obligation or whether you state it as giving a realistic opportunity or state that there's an affirmative duty on the part of the city or the zoning municipality. There's an implication here that when the city did what it did here, it had to provide for low-income housing.
Or let's restate that. It had an obligation not to rezone in such a way as to exclude certain people or certain housing units.
That's Berenson, yes.
And we don't have to, wave the Mount Laurel flag or the affirmative duty flag. We're talking in terms of the obligation of balancing a plan.
But I think the basic point that we're making is that you've got to look to the plan. And the plan isn't just one amendment. The plan is the zoning resolution of the city. The plan is at least what housing there is in that district, in the city of New York, or even, we would say here, in the zoning district. The Berenson case and all of exclusionary zoning cases, as far as even Mount Laurel, because we think even if you applied Mount Laurel here, it wouldn't make any difference. Mount Laurel is not talking about urban communities where they are, generally speaking, I can't think of any, where there is not low-income housing, and probably a lot of it. In New York City, in Manhattan, there's a lot of low-income housing. There may not be enough, but there's a lot of low-income housing. There are many other places in the state where there are not. In this particular district, in fact, this district was drawn taking out the Al Smith housing project, which is low-income housing, subsidized, government-subsidized housing. We took that out. But even within this district, almost all of the housing is low-income housing. I'm not saying that these amendments were in fact, although I think that there is encouragement of low-income housing, but I'm not saying that that was the purpose. The purpose is stated in the amendments themselves, and one of the purposes is to encourage rehabilitation of low-income housing. But there are many other purposes. I wouldn't tell you that the purpose was not to encourage building, which we assume in this case will provide some luxury apartments. There's no question about that. One of the purposes is to create a community there that's mixed. It makes for a more stable community. I think that that's what Berenson was about and all the other cases were about, a balanced community. That is the context in which the court, I believe, has in the past and should now look at this challenge. Is what the city did in the context of their zoning resolution a balanced plan?
Mr. Hart, before the plan, there was a study, was there not, which identified the need for low-income housing?
Yes, sure.
What effect are we to give the study in our analysis? Are we just to look at the plan, or are we to look at the plan in the context of the study?
I think it a constitutional challenge that you're to look at the zoning resolution and what the amendments did and whether they excluded from that district, I would say from the city of New York, but because you have to look at it in that context, but from that district, does it exclude low-income housing? And I don't think that it does.
If the study identified a need for low-income housing, are we to take that into consideration in looking at the plan?
I think that you can, and I think that in any case, that you would have to find that there is an affirmative, I think you'd have to find a Mount Laurel-type obligation on the part of the city under the New York State Constitution to say that just because we state that there is a need, there is a need. We don't deny that there's a need, and it was stated there. It's a question of, well, can you achieve that now? And also, is that best for this community to encourage that? They also made a finding that there was no practical way, in their view, absent subsidies by government, to create that low-income housing. So I think even if you do consider it, I don't think it would change the result here. I think their attack simply does not state a cause of action under New York State law.
Mr. Hart, if we assume you're correct, that there is no affirmative initiatory obligation to provide the low-income housing, and then if we further assume, however, that the city does something, if you did that on a clean slate, maybe we'd have no problem on that assumption. But if you go to the next step, where the city does something affirmative, doesn't that change the basis upon which you evaluate whether a claim has been stated or a cause of action has been stated? Because might not that initiatory action, which they've taken to change the zoning, which might have a chilling effect, might have a lessening effect on the availability of housing, doesn't that impose a different kind of obligation for pleading purposes, perhaps, in connection with the evaluation of the constitutionality of the zoning plan?
It may in some case. I don't think that it does at all in this case, under these circumstances.
See, because that doesn't require you to go to Mount Laurel if that analysis holds up.
If it does, I don't really agree with the analysis, but I don't think in any case that here, that they've stated that we've done anything like that. I mean, I think that in order for them to prevail, even in terms of stating a cause of action, they have to show that we are excluding, or we are excluding low-income housing from the city of New York.
Or from the district.
Our
Are you
position is
retreating
it's
from
not,
your earlier position?
No, I'm not saying that. I think that, in fact, we are not excluding it from the district. We're not affirmatively doing that. We're simply encouraging housing based on this study. We say we don't believe that, given our obligation to zone for the general public, the health, welfare of the general public, that we're able to do that here, absent government subsidies. But we do see certain needs, which are stated in the study and stated in the zoning the amendments to the resolution, and we've acted on them, and we think that's what this court was referring to in the Ginn case when it looked at the plan and found that it did constitute a well-balanced plan.
You see, speaking for myself alone, looking at the affirmative obligation to provide low-income housing on a clean slate, as opposed to looking at it in the context of a report and a study and a zoning plan which may have an effect on the availability presently or in planning of low-income housing, might have a different outcome on analysis, certainly in connection with the way this has been pleaded.
Well, if the city doesn't have an affirmative obligation to provide for low-income housing, then I don't see how they've stated a cause of action.
Does it have any obligation to implement the study that it commissioned?
I don't believe it does. I think that if we're dealing with the Constitution and whether what they did when they zoned violated the Constitution. I also don't think, from my reading, that when they made this determination, they did violate the study. I think if they did a study and they said, and we find that there's no need for low-income housing, that would be certainly a disingenuous statement. There is a need, and they stated it, but then they said, but we don't believe that in this context of zoning in this area, we can do anything about that absent government subsidies. However, we do see other needs which are stated, and this is what we're going to do. And we did something to encourage low-income housing. I think to say that there's no need for this community to have facilities you know, that's a judgment that an individual is making or a group is making. But the city is zoning, there are elected officials, and it's a political judgment that they're making. I think if the court, that's why the court doesn't want to get involved in that. I think that Judge Wachtler was right when he stated that these arguments really involve a separation of the powers.
That was just a question.
Or, well, I think if the answer was affirmative, that would be a correct interpretation of the law.
Thank you very much, Mr. Hart.
Is it possible to know how much time I have left?
No.
No?
Okay, I'll go as fast as I
When
can.
you see a
Okay.
white light, you know you have 1 minute left.
Thank you. Your Honors, I'm shocked to hear my colleague here keep talking about Mount Laurel when we're in New York State, and he doesn't like to talk about Berenson. If Berenson said anything, it said, you made a resolution, an amendment to the zoning laws. You didn't address the problem of housing.
But Berenson and Udall are talking about well-considered plans on a community-wide basis. If I understand your argument, and I confess I'm having difficulty with it, you're trying to bring those rules of law down to an area of the community. And-
Exactly.
But that takes you outside of Berenson and Udall. Those talk about considering the needs of the community as a whole, not
let's
some
take that.
special Manhattan Bridge district.
I think the cases after Berenson and Berenson itself made very clear that we cannot use rigid applications of the rule. We have to look to the circumstances. The observation I was making is that Berenson said when you make an amendment to the zoning laws, you have to take into consideration all the needs. And for council to say there's no obligation, as His Honor pointed out, once you act, you have to act as per Berenson.
I might pass a zoning amendment which would totally exclude a particular use everywhere north of State Street in Albany, but that doesn't mean I've destroyed a well-considered plan that meets the standards of
That is
Udall
correct.
against Hobbs.
That is correct. However, what Berenson says and the other cases say is that you need to look to the community, and Berenson, if Your Honor, when you read the case, you will note that Berenson says we don't only look to Newcastle, we look to what's going on in other places. So if outside Newcastle there's a need for housing, we may very well have to provide housing for those people outside of Newcastle. Conversely, if there is sufficient housing outside of Newcastle, then maybe we don't need to deal with it.
And that leads to the questions that have been addressed to you. You are, in fact, talking about an affirmative program.
No, because again, my colleague here makes a mistake when he says that we want affirmative action or we want numbers. No, we are saying just what the court said in Berenson. Your job and our job is to prove, your job is to agree, hopefully, that the city has not addressed. I underline the word addressed. They haven't addressed it. And to say that a 7-to-1 FAR and a 2-to-1 for low-income housing and moderate-income housing is a well-balanced plan, I think flies in the face of Curzius. Because in Curzius, what Your Honors pointed out was that when you have a plan that within it has the seeds of excluding people, which the Chinese staff case points out, then the burden shifts to the defendant to defend against an unconstitutional amendment. So what I'm saying is the law is clear. Down below, we want a trial to prove that the city has not complied with the law. On a motion to dismiss, the allegations have to be assumed to be true. And that's how it's decided. On trial, once, and it's really in this appeal, once we show that under Curzius that the effect is exclusionary, then the burden shifts to them. But we're not even at that point yet. We're just asking you to give us a chance to try the case.
Thank you very much.
Thank you very much.
Mr. Alvaro. Matter of State Farm Mutual versus the City of New York. Mr. Tom?
Good afternoon. I understand Lori Finsterwald has argued here before. For those of you who might be wondering why I am substituting for her, she's a recent mother of a robust son. she's spending some time with her newborn. This case involves the relationship of police vehicles to the laws dealing with uninsured motorists. From the city's point of view, I believe the case to be quite simple. That is, can be summed up as follows. The problems of uninsured motorists never had anything to do with police vehicles. The solution to the problems of uninsured motorists, as adopted by our legislature, expressly excluded police vehicles from the plan of that solution. And by imposing upon the City of New York the burden of dealing with the problem of uninsured motorists in the context of police vehicles, what the court below has done is to shift the monetary responsibility from the insurance industry, where the legislature placed it, in my view, and has put it on the municipality. And I think I am not revealing any secrets when I say the municipality can ill afford the burdens it currently carries, let alone any extra burdens put on it that the legislature did not intend.
Mr. Tom, it would be quite an easy matter had the legislature, as you suggest, expressly excluded the city or expressly excluded police vehicles. But in fact, the statute does not so neatly exclude municipalities and police vehicles, does it, in the insurance law?
Well, in my judgment, focusing exclusively on police vehicles, it does in fact exclude them from coverage. And let's examine first what problems the uninsured motorist statute was designed to address. It was designed to address, again in my view, two typical problems. An innocent victim is injured by an automobile. The driver is identified, but is financially irresponsible because the driver is uninsured, as a typical situation. The other problem is that an innocent victim is hit by an automobile which leaves the scene, and so that whether or not the driver of that car is financially responsible, the victim is left without redress. So the statute, in my view, was aimed at those two typical situations, neither one of which applies to police cars. Police cars in the city of New York, of course, if they involve a tortious activity, have the resources of the city standing behind them so they can answer financially. They're a financially responsible source. Secondly, they're identifiable. They have police written on them. They're blue and white. And so that even if they should leave the scene of an accident, the victim would know that a police vehicle was involved. And again, if the victim was innocent, the police vehicle was at fault, could cause the city to respond in tort. The insurance company before the court here, in the Rutherford case, has written not only the basic uninsured motorist coverage, but an excess policy. Now, some 3 years later, of course, they haven't paid a penny on that policy, so that their insured, who bought what he thought was coverage, has not gotten a nickel. Until the cases which are on appeal before this court, the city routinely denied uninsured coverage. The courts that addressed the matter upheld that decision by the city. And it is therefore, I think, a fair and reasonable assumption that the actuarial tables used by the insurance companies to provide their uninsured motorist coverage took that into account. So not only are the insurance companies suggesting that we switch the basic coverage from them to us, but they are also, in effect, suggesting that they should get a windfall, which is the windfall that results from writing the premiums on an actuarial table, assuming the city is going to deny coverage in this situation, and yet argue before this court, as they did below, that the city should be stuck with it.
But Mr. Tom, coming back to my question, you make a very compelling argument, and what you say seems quite logical, but then I go back to the statutes, and I find an exemption for police vehicles in one section of the statute But I look to that's 5502 of the insurance law, but when I look to 3420 of the insurance law, under which this claim seems to be made, I find no express exemption. So that as a matter of statutory law, although it may not be logical, I seem to be led to an opposite conclusion.
Of course, we start with the fact that Article 55 is in fact the section which deals with uninsured motorist coverage, so that the exemption that appears there is, of course, most important in terms...
3420 does a pretty good job, too.
But Your Honor is correct that 3420 does not seem to have that exemption. It does appear in, I believe, 311, but it seems to me that the most crucial place for the exemption in terms of uninsured motorists would be the very statute which deals with that topic.
May I
which is Article-
ask you then about that, because I'm not sure I understand it. In 5201, it appears that uninsured motor vehicles, that term is defined, as I see it, as the motor vehicle which does the damage, the hitting, and which is uninsured. And the exemption appears to be an exemption from the definition of motor vehicle. Means a motor vehicle is defined in Section 125 and shall exclude fire and police vehicles. So it seems to me that the exemption, I would have difficulty in applying the exemption here, which, as I understand it, is to a case where the police vehicle got hit and the policeman was in the police vehicle. The police vehicle is not the car that did the hitting. You see what's troubling me?
I understand. Let's start out with the proposition that the city believes that both police officers were covered under the facts in these cases by uninsured coverage. It just wasn't coverage by us. It was coverage by their insurance carrier.
Right.
In the decision of the court below, the appellate division appears to take the position, as I read the case, that this exemption is for the benefit of the Motor Vehicle Accident Indemnification Corporation, and that what it prevents is that if a police vehicle is involved in an accident in which it is at fault, the injured party cannot go to the Motor Vehicle Accident Insurance Corporation and claim that the uninsured vehicle was the police vehicle. Now, the situation that you're addressing, there is an uninsured vehicle, and that is the vehicle that did the striking of the police vehicle. And if there had been no insurance policy in this case, the city's position would have been that Officer Rutherford could go to the Motor Vehicle Accident Indemnification Corporation and say that he was the victim of an uninsured vehicle, to wit, the one that hit the police car.
But what in the statute says that that shouldn't be the case here?
Well, it seems to me there are only two positions as to what the legislature was trying to exclude when they took police cars out of the scheme. They're either trying to say that the insurance industry, which funds the Motor Vehicle Accident Indemnification Corporation, should have a lesser burden put on it because we're not going to include claims by police vehicles as the striking automobile. Or they were saying, and this of course is what the city thinks they were saying, is that since police vehicles were never part of the problem sought to be addressed by this statute, we're not going to make them part of the solution. To the extent I have any time left, I'll reserve it.
Thank you very much, Mr. Tom. Our best wishes to Ms. Finsterwald. Mr. Herman?
Yes. Good afternoon. After listening to Mr. Tom, I might say that I agree with one issue he raised, and I believe it was clarified by Justice Hancock, is that we are not claiming that if the police car is uninsured, that the city should pay uninsured benefits. We are, as I believe Justice Hancock brought out, it is where the other vehicle is the one that is the uninsured vehicle. Now, when this court decided Countrywide Insurance versus Manning, approximately 4 years ago, it was my impression that this court adopted what I felt was a doctrine of fairness, in that the financial security burden, which involves liability protection, uninsured motorist protection, and no-fault protection, should be borne by the owners of the vehicles. Countrywide against Manning, this court held that the city of New York should bear the burden of providing primary uninsured coverage as the amount provided in Section 3420, Subdivision F1 of the insurance law, which is the basic 10 and 20 for bodily injury, 50 and 100 for death. Interestingly enough, in looking over the record in Manning and in reading an affidavit of Daisy Manning and in looking over the police report that's also part of that record, it appears that the vehicle in the Manning case, from which this court ruled that uninsured protection should be generated, was in fact a police vehicle. Daisy Manning was a parking enforcement agent, stated right in the record in Countrywide against Manning. The vehicle was a parking enforcement vehicle. It did not have any state license plates on it. It had a tag corresponding to the number of the vehicle. Perhaps it was coincidental, perhaps not. However,
Certainly wasn't a major factor in the decision.
no, it was not, Your Honor. What's more important is the fact that we consider the uninsured motorist protection, as stated by the legislature in Section 5201, as filling a particular gap, a need that is addressed when there is a vehicle that causes a person pain and suffering that is uninsured. There is no program that the city of New York has in effect that compensates a police officer or a fire officer or anybody else occupying one of these vehicles when involved in an accident with an uninsured car. In fact, in addressing a similar issue in uninsured motorist law, this court was confronted with a problem approximately 22 years ago in a case called Eisenberg against MVAIC. It's reported in 18 New York 2nd at page 1. In that case, it turned out that Eisenberg was involved in an accident with a hit-and-run vehicle. However, the hit-and-run vehicle did not strike Eisenberg or Eisenberg's car directly. It had struck another vehicle that was traveling in the same direction on the Long Island Expressway, which in turn caused it to come over to the opposing lane of the Long Island Expressway and strike Eisenberg, the hit-and-run vehicle being long gone. The question was, did that constitute physical contact within the meaning of the hit-and-run statute? If you take a literal reading of the hit-and-run statute, it would be certainly arguable that it could not. However, this court saw that a terrible injustice would be done to a person for whom this statute was enacted. And in holding that such type contact constituted physical contact within the meaning of the statute, although the words did not say so themselves, this court stated that question can only be resolved by looking to the enactment as a whole, by discerning the purpose and policy underlying the statute, and by giving the words a meaning which serves rather than defeats the ends intended by the legislature. And that's exactly what we're looking for here.
Mr. Tom says that's exactly what he's looking for also. And looking at the legislation as a whole and its purpose, that it obviously was not intended to achieve a result such as the appellate division reached.
The appellate division reached that result primarily because this court previously reached the result which it did in Countrywide against Manning. Prior to the issuing of the decision, in this case by the appellate division had ruled in a case called Nassau Insurance versus Guerrasio, in which I had represented Nassau Insurance, that the city of New York was not required to afford uninsured protection for the occupants of city vehicles. And they said that under those circumstances, the claimant would have to go either to MVAIC or to his own insurer. In the Guerrasio case, Nassau happened to be the personal insurer of Guerrasio. However, in essence, the Guerrasio case was reversed by this court in the Manning case. The Manning case says everybody should afford financial security as far as the premium that was paid for excess coverage, uninsured coverage, or supplementary coverage by Rutherford to State Farm. That is not gone. Rutherford comes online after the primary coverage of the city of New York is exhausted. He has $100,000 coverage, and since this court held in United Community Insurance versus Mucatel that there would be no reduction, Mr. Rutherford, if his injuries warranted, would be entitled to a total of $110,000 of uninsured protection, of being $10,000 from the city and $100,000 from State Farm. But nevertheless, and I go now,
It's been nice having you with us.
thank you, the primary coverage should be afforded by the city.
Mr. Majewski?
If it may please the court, I have an extremely limited argument as to the additional respondent at the casualty and surety company. Both State Farm and the City of New York have raised no issue as to the uninsured status of the McCary vehicle which struck the Rutherford vehicle. I simply submit that that finding is not at issue before this court and should be affirmed no matter what the result herein. Thank you.
Thank you very much, Mr. Majewski. Rainbow versus Swisher?
Ready at the floor, please.
Mr. Martin, this challenge that's raised now was not challenged at the time that the judgment was entered, was it?
Do you mean the underlying divorce action?
Yes.
That is correct, Your Honor. There was no direct appeal from the divorce decree itself. I recognize that as an important issue before this court, Your Honor. I believe it's explainable from the record that the divorce decree that was obviously served upon my client late in 1978 indicated that all future matters, I think, regarding visitation, support, maintenance, and custody were to be referred to family court. And that is exactly what the parties did, or what the plaintiff wife did on several occasions subsequent to the divorce decree. She pursued actions in essentially the equivalent of the family court in the state of Connecticut. After having lost on 2 or 3 occasions there, she finally came back 5 years after the divorce decree and commenced this current action for a breach of contract, claiming that there was still an outstanding and valid separation agreement. From all my reading of the cases, Your Honor, I believe that our defense to this action was properly and timely raised. Perhaps he could have done it also at the time of the divorce decree, but as I indicated, because of his reading of the divorce decree, he understood that all matters were to go back to family court anyway. I think this is a case of a simple typographical error contained in the divorce decree. I think the trial court in this particular case, this breach of contract case, simply arrived at the wrong conclusion and based their conclusion on the Knopper case. I think this court is well aware of the decision in Knopper. It's clearly distinguishable and essentially indicated that the court might come to a different conclusion if a defendant raised the issue in defense at the trial court level. We did raise that issue, and I believe that it's properly before this court. The other thing that I believe we should talk about this afternoon is if this is simply a typographical error, we're really dealing with the decision of 2 courts, and opposing counsel has argued in his brief that there's an ambiguity.
What would be the typographical error? The word "not" was omitted, is that it? Not to be merged, or
The word not.
exactly what would the error be?
Well, the stipulation of the parties, the separation agreement, provided that that agreement or that contract was to be incorporated and merged into any subsequent decree. Both of the parties clearly acknowledged that there was a subsequent decree, but the decree provided that the separation agreement or the contract was to not merge, which has the effect of continuing the agreement and allowing a breach of contract action to be brought on that.
So it's the inclusion of the word "not."
That's correct.
If you're correct that this is a typographical error situation, and we have a jury trial with findings and award of damages affirmed by the appellate division, what's the surviving question of law for us to review which would have any legal effect in this case?
Is your question related to the trial and this breach of contract action?
I'm curious as to how we extrapolate from a typographical error, a legal principle with an affirmed set of findings here.
Well, there are 2 different trials, if I could separate the 2 different trials. And one was the fact that the parties clearly, over a several-hour period and perhaps a several-month period, negotiated a separation agreement, which is clear and explicit on its face. The decree is contrary to that. The decree provides that the separation agreement is to survive. The trial in this particular action was a non-jury trial. The court, as I recall, essentially concluded that there was insufficient evidence to determine what the intent of the parties was regarding survival or merger of the separation agreement. I submit that that issue, if you look at the agreement itself, the contract of the parties, is a legal issue. The contract is clear and explicit on its face. The interpretation of that contract doesn't require looking beyond the 4 corners of the document. I think it's simple contract law that, first of all, the divorce trial court had no authority to continue, the separation agreement as a contract. And secondly, there was no evidence, first of all, that the court, in this case, the trial court, should have considered to come to the conclusion that the separation agreement was continued. And secondly, it only should have looked, there was simply no other evidence of intent. The only intent shown was by the document itself, by the separation agreement.
Why isn't the judgment of divorce itself evidence of intent? It says that the separation agreement shall not merge, and can we not assume from looking at the four corners of that document that the husband's intent, whatever it was at the time of the agreement, changed so that it was compatible with what's stated within the four corners of the judgment of divorce?
I don't think we can do that, Your Honor. I think that understanding what occurred on May 3rd of 1978, the parties negotiated a separation agreement. Both parties then appeared before the Supreme Court Justice, and my client acknowledged that he had negotiated the separation agreement, acknowledged his signature, and then said, okay, I will withdraw my defense to this divorce action on the understanding that my separation agreement, the terms of that separation agreement, are going to be merged, this was not said explicitly, merged in the divorce decree. Now, his option at that point was not to withdraw his answer. If he had maintained his defense and the Supreme Court Justice had made a decision on all of these various factors, support and maintenance and custody and so forth, there would be no underlying contract that she could sue on.
Who put the divorce decree in? I assume the plaintiff.
That's correct.
And so, obviously, the proper procedure, which wasn't followed, but apparently due to oversight, was to move to resettle the decree, and failing success on that, then enter a denial of that and appeal.
That's correct.
Now, having not done that and having raised this issue 5 years later, is that not a collateral attack on the decree?
I think it is.
Is barred.
Pardon?
Is that not a collateral attack which should not be made 5 years later?
I agree with the characterization that it is a collateral attack. I can't find any cases which indicate that my client is prohibited from a collateral attack. All of the cases essentially cited by both sides involve a situation where the stipulation itself is either silent or ambiguous regarding the intent of the parties. The trial court, the divorce trial court, in each of those cases then either on its own or through some sort of inquiry determined what the intent was regarding merger or survival of the separation agreement. So I don't think those cases, and those cases essentially conclude that the remedy of the aggrieved party, the party that doesn't believe the decree is correct, is to appeal. But here, I think from the circumstances of the case and what had occurred, four corners of the document, and the fact that the court had no authority whatsoever, no other evidence to determine intent, made no inquiry regarding intent, and my client walked away from the court expecting that all matters would be referred to family court, I think allows this collateral attack.
Thank you very much.
Thank you.
Mr. Gordon. Mr. Hill?
Please the court. I'd like to just pick up quickly on a remark that counsel just made, which I think is inaccurate. I don't think he meant it directly. He stated that the court did not find sufficient evidence regarding the intent of that agreement. That's not what Judge Murphy said. Judge Murphy specifically did say that as to the sixth alleged offense, the court specifically found as a fact that there was insufficient evidence to warrant a finding that it was the intent of the parties to incorporate and merge the settlement agreement into the divorce decree. It was specifically found by Judge Murphy that there was no intent to merge that agreement. Period. That's a finding of the trial court, which has been affirmed by the appellate division. I'd like to mention very briefly, or as an aside, that if not for a motion made by me at the time preceding the trial to amend my complaint, this case is the Knopper case. Both counsel in this case were not representing the parties in the initial instance of the divorce in 1978. I very briefly remind this court of the salient facts here. The divorce was May 1978. The Connecticut Family Court, where both parties participated in the judgment of divorce, which was a proceeding in Connecticut on two different occasions in 1980 and 1983, both parties participated. Neither party objected to the divorce decree. 1983, the summons and complaint is issued. 5 years later, first motion made by defense counsel. All of the papers are before this court. Not one word is mentioned about, quote, intent to merge. And parenthetically speaking, the judgment doesn't, the agreement doesn't talk about shall not merge and shall survive. It just says shall not merge, period. There wasn't that extra phrase that you find in every single separation agreement that I've prepared, and I would assume this counsel has prepared. Then we have the first answer, 1984, 6 years after the judgment. Still no raising of the issue that there was something wrong with this divorce decree. And we start to litigate after one motion, after two Connecticut court hearings, and then a second motion. That one was made by me for summary judgment. Still, no answer, no claim that there was a different intent. So everybody assumes now that this separation agreement is valid and it's enforceable and it's based on a judgment of divorce. It wasn't until I'm in negotiating with Mr. Martin, as a matter of fact, in front of Judge McLaughlin, I believe, not sure of the judge, I told him informally, as I'm talking now, by the way, Judge, at the time of trial, in a few months, I'm going to move to amend my complaint to conform to the pleadings so that I can bring in all of the arrears from the date of 1983 to 1987. Oh, sure, no problem. But why don't you do it formally? I don't remember if that was the judge's remark or Mr. Martin's remark. If it was Mr. Martin's remark, then I think I got set up, in effect. But anyway, I did make the formal motion to amend the complaint, and the only difference in that complaint was that I moved to extend the period to the date of trial. For the first time, we got an answer that talks about different intent. Mr. Martin says that this was an explicit agreement and can be found in the four corners of the document itself. I say that's not really true. You can look at this case from a different standpoint. The question is, was the separation agreement, stipulation agreement inaccurate, or was it the judgment of divorce inaccurate? Mr. Martin says the judgment of divorce was wrong. I don't maintain that's true. I think the stipulation was wrong. If you read the record, you see the original separation agreement that was prepared by counsel for plaintiff and rejected by counsel for defendant. Imagine yourselves, if you will now, you're back in trial 20 years ago. Some of you judges, I don't know exactly when you were. You're negotiating with opposing counsel. You take a separation agreement and you start cutting it up. And you patch it, and somebody runs out and types it and brings it back in again. That's exactly what we're told happened in this case. And finally, a document, and you can see by looking at the photocopy of it, this was a patched up agreement. And all of a sudden, there's a statement in that says the judgment, the separation agreement, stipulation of shall not merge, period. It doesn't say and go on and use the language that was found in the original agreement, and language that I'm sure this court is familiar with, and shall survive. It just says shall not merge, or shall merge. The word not is not in there. I maintain the error, if there was an error, was made in typing that agreement. The intent of the parties was that it shouldn't merge. The intent of the parties was that it should survive. I've never seen an agreement in 30 years of practice in Onondaga County. I've never seen an agreement yet that's prepared by any lawyer that did not have a separation agreement survive. And what's the reason for it? It's obviously simple. You get two whacks at your other party. Every single spouse has an opportunity to sue in family court, and if that's unsuccessful, sue on the contract. And if we're talking about equities here, we're talking about a serious problem for Mrs. Rainbow. Her husband went to the state of Connecticut, where in Connecticut, through uniform support, you're only allowed to collect child support up to age 18. In New York State, you're allowed to collect support 21. This contract provides, it's enforceable in New York, and that's why she came back to New York. When she was unsuccessful in Connecticut, she called me. And I looked at the agreement, I looked at the decree, and I brought an action on the contract in the state of New York because she has more rights in the state of New York. I'm reminded, this will sound strange, but I'm reminded about taking the bar examination 30 years ago in the city of New York. On stage was a fellow by the name of Lewis Cass. He was the one that gave the bar review course. Probably don't know him. One thing I remember that he said, among other things, if you don't know the answer to a question, gentlemen, fake it. Make up an answer. And how do you do that? You take what seems logical, what seems fair, and you make it the law. And 9 out of 10 times you'll be right. Well, if we apply the logic here, what's fair and what's logical and what's equitable, it's simple. The agreement survives. And Mrs. Rainbow's $19,000 judgment that she'll never collect any other way should be enforced. And also, she shouldn't be forced to continue to go to Connecticut. In Connecticut, she can't recover because of the different law relating to the children. I'm looking at the McDonald, Goldman, and Shainin cases, which provide very simply that you must not allow a collateral attack to a judgment. In both McDonald and in Goldman, those particular agreements were silent. There was nothing said about survival. And what happened there is the court made a judgment that allowed the agreement to survive. And in both of those cases, and also in the Shainin case, which was there was nothing in that one, all 3 cases the court held that the agreement shall survive. And why? Because they said you had an obligation to appeal. You can't just sit back and do nothing. If you don't appeal, you assume that the judgment is correct. And even though the agreements didn't provide it, the court in all 3 cases held that you cannot collaterally attack the judgment and the agreement is going to survive. I think that's basically it. I feel that based on the equities, based on the law as it presently exists in the state of New York, all of the appellate division cases, there isn't one case that I was able to find that would reverse this case in this court.
Thank you
I
very
ask
much.
it be affirmed.
People versus Carl Collier.
Ready, if more, please.
Mr. Tsimbinos, the statute seems rather clear, doesn't it?
It depends on which way you see the clarity, Judge. I see the clarity with respect to the support for the trial judge's decision that the quorum requirement here of 16 actually means 16 people that were present and heard all of the evidence. I think the significant difference here is that from the old CCP, the statute was changed, and under the present CPL, rather than talking about generalities about the composition of the grand jury, we have language that talks about the proceeding and also talks about a motion to dismiss the individual indictment. I think those changes were significant and lead to the interpretation that Judge Kofinas had in this case, that if we're going to talk about a logical explanation of what was meant by the legislative body, when you're talking about a quorum of 16 people actually being present, you're not just talking about bringing bodies in so that we can mechanically reach a magic number. We're talking about 16 people who would have heard all of the evidence and are in a position to deliberate. I think also what's important is the grand jury is an investigatory, deliberative body. The concept is that all of the people who are participating in this proceeding should have all of the input that was given to them. We're not talking about a similarity where we're enacting a legislative statute and the legislature could run in and out and we have that kind of a quorum requirement. We're talking about a quorum requirement going to an individual proceeding. It's very important that all of the 16 people who heard all of the evidence participate in the deliberation. I know the argument is going to be made that 12 people who heard all of the evidence concur, therefore you reach the minimum number of 12. But I think that's a fallacious argument, because if 4 additional persons heard all of the evidence, they might have an influence on the vote of those 12 by being able to point out to them some of the evidence that was presented or weaknesses in that evidence. So that the concept is that you have 16 persons present who heard all of the evidence, and out of those 16, then the vote of 12 would be taken. I think support of that is also gained by the fact that you have the 2 separate provisions in the statute. Otherwise, if all that is required is 12, who heard all of the evidence. And why have a quorum requirement of 16 in the first place? That would be something that would be extra that was thrown into the statute, which I think, there's almost a presumption that the legislature doesn't throw in extra pieces of legislation if they don't mean anything. So I think what's significant here is that when we look at the entire framework of the statute under the new CCP, I think that under the criminal procedure law, rather, that indicated a change and was a departure from the language of the Brickman case and the Stapperstein case. And I think, again, when we're talking about logically and the function of the grand jury, I think there's a famous phrase that has been going around that a grand jury, based upon the prosecutor's information, can indict a ham sandwich.
Just change that to chicken salad.
Oh, whatever, Judge. I think the ham sandwiches need additional protection in this case. And I think if we're going to talk about the integrity of the grand jury, 16 persons, okay, who heard all of the evidence and had a chance to deliberate and to make their opinions known to the other 12 is what was required and what is meant by the statute.
Thank you very much, Mr.
Thank
Neves. Mr. Weinstein, why isn't there much to that argument? The statute says that there's a quorum of 16 and you need 12.
Well, Your Honor, this court has already answered that question. 16 grand jurors were present at every stage of the proceedings in this case. And
Yeah, but could those 16 vote and deliberate?
No, Your Honor. In fact, the grand jury was told that only
They
those
were
12 that had
so
heard all.
therefore, why have 16? Why not just a quorum of 12? Why'd they say a quorum of 16?
Well, the quorum requirement serves a number of purposes, which we point out in our brief, and as the appellate division noted in Infante. First of all, the presence of 4 additional grand jurors,
Can't vote.
even who can vote, but the additional,
Who can't discuss the case.
no, but those additional grand jurors can, as this court noted in Salerno, and as Judge Rothwax noted in Colbert, could, if they wanted, call for testimony to be reread, could call for witnesses to be recalled, and could, in fact, at some future point in the proceedings, become voting grand jurors. In addition, the mere presence...
How could they become voting grand jurors if they weren't present when all the testimony was taken?
if they had the testimony reread to them. In addition, the presence of 4 additional grand jurors serves additional functions as well. First of all, they serve as an additional, and as the appellate division, as I started to mention before, noted in Infante, the presence of 4 additional grand jurors serves as a check itself against unfounded accusations and abuses of the process itself. It serves some sort of deterrent effect on those 12 grand jurors who will be voting in the case. And in addition to that, the quorum requirement of 16 at the outset of a case serves the even more important purpose of increasing the likelihood that when it becomes time to actually vote in the case, that there will be 12 grand jurors who have
That's why we start with 23.
Frequently, however, in grand jury
That's why we
presentations,
start
there's
with
far less.
23 and say a vote of 12, but a
Well,
quorum of
grand jury does
16.
not necessarily start, it may start with 23 on the day that grand jury is first assembled, but absenteeism in the grand jury is a serious problem that any experienced prosecutor confronts all the time. It's because 16 grand jurors must be present at all those stages of the proceedings that there's at least an increased likelihood that when it's time to vote, there will be at least 12 grand jurors. This court in Brinkman and Saperstein had the opportunity to examine statutory language virtually identical to the language at issue in this case, and this court in those cases specifically found that an indictment could be voted so long as 12 grand jurors had heard all the critical and essential evidence and voted an indictment. Indeed, in Saperstein, only 13 grand jurors had heard all the critical and essential evidence, and this court said that was enough. Principles of stare decisis compel the same conclusion here. Absent a clear indication from the legislature that some change was intended, this court should not depart from the holdings and from the rulings which it reached in those 2 cases. And I say that for 2 reasons. First, stare decisis is particularly appropriate when the prior decision concerned not an issue of constitutional interpretation, Constitutional documents, as we know, are living documents and subject to varying interpretations as years pass. But where the prior interpretation concerns, or excuse me, where the prior decision concerns interpretation of a statute, this court should find that unless the legislature has chosen to overrule that prior decision or rewrite that prior legislation, the court should be led to the conclusion that its prior interpretation was correct. For if the court makes a mistake, the legislature is free to rewrite and amend the statute. And second, prosecutors throughout the state, and certainly as is evidenced by this case, prosecutors in Kings County, have been relying for 30 years on the rule that this court announced in People v. Brinkman and People v. Saperstein. Indeed, it's apparent from Colbert and Partridge, two of the cases cited in the parties' briefs in this case, that that's the practice that's been followed in the New York County DA's office as well. Therefore, even if this court were to now think that a different rule would be better, it would be unfair and improvident for this court now to change that rule and to depart from its prior holdings. Any change should come from the legislature in this case. And for all those reasons, I would ask that the decision of the appellate division be affirmed.
Thank you, Mr. Weinstein.
All please rise. Hear ye, hear ye, hear ye. All persons having any further business before this Court of Appeals, held in and for the State of New York, may depart hence, and appear here tomorrow afternoon at 2 o'clock, to which time this Court now stands adjourned.